Hello, good afternoon, everyone. My name is Dawn Bauman. I'm CAI Senior Vice President of Government and Public Affairs. Welcome to today's CAI Florida Legislative Alliance update. We're so happy that you are able to join us today. We have an excellent panel of presenters for today's program. We'll be here for about 75 minutes together. You'll see on the screen right now, we have Travis Moore, CAI's lobbyist. Thanks for being here, Travis. Michael Bender, an attorney in Southern Florida and CAI's chair of the Florida Legislative Alliance, and Mary Macfie, who is a commissioner in Weston, Florida, and also on a delegate on the CAI Florida Legislative Alliance. We also have others who will be presenting specific issues that have either passed or failed during this year's legislative session, and we'll bring those folks on camera as they present their materials. But we want to start today with just first letting you know that today's program is, while we have several attorneys, insurance experts, lobbyists, and other professionals on the call, the material that we're presenting today should not be taken as legal advice because we don't know the special circumstances or the governing documents in your community. We don't know the circumstances that you all face. We're just trying to provide you with information about the laws that were considered in the 2020 legislative session and share how those laws may or may have impacted you. So let's talk a little bit about the let's give an overview of the CAI Legislative Alliance. So CAI has legislative committees in 36 different states. The CAI Florida Legislative Alliance is made up of representatives from each of our Florida chapters. And we have a balance of representation on the Florida Legislative Alliance of each membership category. So we have managers and management companies represented. We have homeowner leaders, board members of community associations represented, and then the professionals who represent community associations. We're fortunate enough to have attorneys, insurance agents, bankers, and others serving on our Florida Legislative Committee. It's a super important committee because this committee reviews, analyzes, tracks legislation impacting community associations in Florida all year round. And during the legislative session, they are on calls at least weekly, talking about the legislation, engaging the grassroots, negotiating with legislators, etc., to do what we can to make sure the interests of Community Associations Institute members are represented at the Capitol. As I mentioned, we have a phenomenal lobbyist in Travis Moore. Travis has been with us for more than a decade, and I've had the pleasure and opportunity of walking around the Capitol in Tallahassee with Travis, and he does amazing work for us, for all of our members, and we're lucky to have him on our team. Everybody knows him and everybody loves him, so we're lucky. Each year, the Legislative Alliance sets priorities and tackles those priorities during the legislative session and then plays defense on whatever issues happen to be coming up regarding community associations. So that's our Legislative Alliance, our purpose, and why we're here today, sharing this important information with you. I'm going to turn it over to Michael Bender, who is chair of the Legislative Alliance, to share some additional information. Michael?
Thank you, Dawn. Good afternoon, everybody. I hope everyone is staying well, being safe. As Dawn mentioned, I'm Mike Bender. I am the chair. I've had the privilege of being the chair of our Florida Legislative Alliance for the past 2 years and working with Travis and with all of our delegates throughout the state. And what I'm going to briefly talk with you about is how we develop our objectives for the coming year and how we set our priorities among those objectives. Because this is where you, thank you all for listening, this is where you can come into play and really help us with what we do and how well we do it. So the way we develop our objectives is, quite frankly, as Dawn mentioned, and I want to really piggyback on that because I think it's important. CAI Florida Legislative Alliance is a cross-section of many different aspects of the community association world. You have a cross-section of attorneys and insurance agents and community leaders, bankers, accountants, property managers, every aspect of the community association world, business partners and volunteer leaders are involved, and it's throughout the state. There are 8 chapters, and we have delegates, 2 or 3 delegates from each of our chapters. So we all get together, and what happens is what we do is we seek feedback from our CAI members. We're all out and about in the community, and we ask and we encourage feedback from our CAI members on issues that you in the real world that you see impacting your communities. Obviously, those issues that impact more communities are those issues that we're more going to be likely be more effective for us to take on as objectives for the coming year. But that is how we do this. We go out and we ask our members through our board meetings and our member initiatives and networking events. And even if you're just want to reach out to some of us with your ideas, your thoughts, your concepts based on your own experiences. We, as there's 24 of us, 24 delegates throughout the state, we get together and take that information, our own and our own objectives that we've established through our own practices, whichever industry we happen to be in, including homeowner volunteer leaders like Mary and others, and we meet on a monthly basis. It's a conference call generally every month. We try to meet in person 2 or 3 times a year. Obviously, we're on hold right now. And then once a year, either in August if session starts in January, or September if session starts the following March, we actually get together at a central location, and hopefully we'll be able to do that in person again this year, and spend a half a day or more going over all of the objectives that have been discussed, some that we worked on perhaps in the prior session or at prior sessions, on what we consider offense, the positive steps that would positive pieces of legislation, as well as those pieces of legislation that were around in previous sessions that we, as Dawn mentioned, played good defense on. And we'll talk a little bit more about that. Some of our panelists will talk about that more later. But during that half-day session, that's when we set our priorities. And Dawn and Travis join us at those meetings, and so that they're able to give us basically the feasibility factors of those objectives, so that we can then set our priorities in accordance with what we'd like to see pass, what we'd like to put together in a bill that CAI year after year, our Florida Legislative Alliance has a bill that's an engine for good community association pieces. And then those aspects of legislation that's out there or that may be on the forefront that we want to keep an eye on, and to the extent necessary, start putting in some defense. So that's basically how we set our objective. We create objectives and then set our priorities. But this is the reason why we need all of you to become active members of CAI and participate in our legislative action. It's been very successful over the past 12, 15 years that we've been working together and going up to Tallahassee. And I think it's a very important aspect of what we do as a chapter. Dawn?
Thank you so much, Michael. I'm going to turn it over to Travis Moore. He's going to talk a little bit about working with legislators.
Thanks, Dawn, and thank you, everyone, as Michael said, for joining, and for you delegates that are joining me as panelists today. I appreciate it. As we take the priorities that Michael talked about and we discuss them, and the delegates come up with their set of issues that they want to propose, we then go and work with a legislator. In the state of Florida, we have to work with a House member from your Florida House of Representatives, and then also a senator, and get them both to file the same legislation as companion bills that we're able to then work with them in the drafting of it. We give them the information. They then, obviously, with their attorneys with House and Senate bill drafting, draft the actual legislation itself. We then discuss it back and forth. If it's a piece dealing with insurance, we're able to pull our insurance person into that. If it's something dealing with accounting, we have accountants that we can pull into. If it's something dealing with a legal aspect or a homeowner issue, we're able to deal. We have the resources and the people within the delegation and the delegates to be able to have the right person looking at that piece. It then becomes the legislator's product. And then it goes through that legislative process that we have to be working on. And then, as Dawn mentioned, those monthly phone calls and conversations that Michael alluded to become weekly. and in some cases daily. But we're able to pull together our group and say, hey, this legislator has a question about this piece. What do you think? Or we've got a situation where we need to have this bill heard in committee. We need to send out a call to action to all of you and others that can weigh in on those pieces and say, hey, this is important to my community. There's been a lot of polling and discussions with like legislative staff that have talked about what's the most effective way of communicating to a legislator? Who's getting that legislator's attention? And quite honestly, much to my chagrin, it is not the lobbyist, it's you. And it's those that are living and working and volunteering and serving on boards and in these common interest ownership settings. You're the constituents. So we're able to identify and say, okay, this is the members of these committees. We're all over the state. So obviously we're going to have members that are constituents of that particular member. Let's engage those folks. And it becomes a puzzle and a process whereby we can get those bills through the process. Oftentimes a bill gets referred to at least three committees in both the House and the Senate. And a lot of times these bills, as they funnel through the system, certain bills kind of stop and don't continue through. If it's one of our bills, we want to take that and move it to a moving vehicle, and a vehicle that's germane to also the community association issues. And as we discussed today, and other panelists talk about specific bills and language that passed during this session, you'll see how some of that works. But that's the way we're also, then we become magnets, let's say, for other pieces of legislation or other language that finds its way into our bill. So oftentimes we'll have a bill, it'll start off in a committee, it'll be about 54 pages, and it's language that we specifically have approached the legislator to file and have worked on, and then all of a sudden there'll be amendments and other things will come, and then that's how you look at a bill later and you say, wait, how did this bill get to be 107 pages? And it's because it may have been part of another bill, and as things move and don't move during that legislative process, we have to stitch those things together. So we have to get those sponsors. We then have to get it through the committee process, and then it goes, if we're fortunate enough, it then goes to the floor, and we have to have the same language pass the floor of the Florida Senate and the Florida House. When that same language passes in those same vehicles, it then goes to the governor, and the governor then can either sign it or veto it, or it becomes law without his signature. And we'll talk a little bit about which of those bills have made it through that part of the process and have either become law already due to Governor DeSantis signing them, or are going to be presented to him soon.
Excellent. Thank you so much, Travis.
Sure.
Now, I think after sharing that process with us, what's important is how can the folks on the call engage and get involved in the process? You said legislators need to hear from them. So Mary, talk to us about how they can do that.
Oh, we are so blessed to have a website that's very comprehensive with CAI. I believe you'll be sharing that as well. It's caionline.org. On this website, you can find Advocacy Action Center. You can get an advocacy toolkit. You can find out who your legislators are, how to reach them. You can literally log on to the supervisor of election and request an absentee ballot, make sure that you're registered. And in Florida, we do have 8 chapters. So through those chapters or through national, people like Dawn, thank you, you disseminate information, whether it's national, federal things that we're working on, state things that we're working on, and the chapters are able to disseminate things that we want out on local levels. So it's vital that each of you pay attention to those emails that come across asking for your support. Also on caionline.org, you'll be able to click on some of those issues and join the forces. We live in a state with approximately 10 million people, with approximately 48,000 associations. Could you imagine what we can do as advocates for association issues if we band together on any issue? It's incredible. And that's kind of what spurred me on as a community advocate to run for an elected position. There are so many ways at the local level that you can reach out to your elected officials. They want to hear from you. Most elected officials do not understand the intricacies of associations, but we want to learn about them. We want to be able to help. That's why we run for office. So reach out to your elected officials, contact them. Let your board members, if you're a manager, know what's happening. As board members and managers, make sure your residents are up to date on issues that are affecting them, the way they live, their finances. All of these issues play together in one big package. Literally invite elected officials to come to association meetings. They would love to come out and hear what the issues are. They want to stay on top of things that are taking place in their community. And if we all band together, we would have a much stronger voice. So we just got to make sure we pay attention to those emails, those text messages, those phone calls. Get out there, pay attention to them, and join forces.
Thank you so much, Mary. Okay, now we're going to get to really the meat of the program, which is what happened in the 2020 legislative session. So what I'm going to do is I'm going to bring those speakers up one at a time. I'm going to bring up Lisa Magill, who is an attorney also in South Florida. Mary's going away, not too far, but she's going away just briefly. Hi, Lisa. Thanks for joining. I'm also going to bring up Curtis Hamlin, who is also an attorney and former chair of the Florida Legislative Alliance. I'm going to turn my camera off, but I will still be here, I promise. And I'm also going to, so I have Barry, Lisa. Oh no, do I have Barry? I'm going to add Barry on as well. So I have Barry, Lisa, Barry Scarr, who is an insurance professional. He will be joining us.
Howdy.
Barry, are you on?
I'm on.
Okay, I can't see your camera. I think I sent you a request. If you just hit OK, that should turn your camera on, or turn your own camera on. I'm going to turn it over to Curtis. There you go. I'm going to turn it over to Curtis so you can start talking about vacation rentals.
Okay. Good afternoon, everyone. I'm Curtis Hamlin. I'm an attorney in Bradenton, Florida. I've been a FLA delegate since 2010, and I had the pleasure of serving as the chair of FLA in 2017 and 2018 legislative sessions. And I concentrate my practice in the community association area specifically. And one thing that's very important in Florida is rentals, vacation rentals, whether in a community or in one of our communities or in a community where it's not regulated by a declaration of condominium or declaration of covenants. And it's the rental aspect has been very important on both fronts. We first came up against a rental issue on the community association side in 2018, where the long-term rental people wanted to be treated the same as in respect of amendments, about the same as you treated in condominiums, and we beat that back, and it's come back every year since then. Vacation rentals in many of our communities are, and when I say communities, I mean municipalities as opposed to associations. That's a very big issue with our local governments, and for years there's been a tug between the municipalities and the state government over regulation of vacation rentals. The two bills that I'm going to talk about, neither one of them passed, but we think, and we're almost certain, that they're going to be coming back. And I want to point out one thing that was in those bills that's very important to our community associations, because what was going on is that there was an effort to have DBPR, the Department of Business and Professional Regulations, through the Division of Hotels, oversee all vacation rentals in Florida and preempt local regulation of those entirely. That didn't occur, but there was something put in that bill early on, and this is something that we knew was going to happen. So Travis went to the sponsors of the bills and had them put in language that specifically excluded an association created or a document created under Chapter 718 for condominiums, 719 for cooperatives, or 720 from the effects of that legislation. And that was in the bill, in both bills when they were originally filed. And if you were to go back and look at the legislative history, you would see that the bills initially were somewhat simplistic, but they grew over the session. And our section went from section 6 to section 18 in the House bill. That the Senate bill never quite caught up with the House bill. But what was evolving was this idea that Tallahassee should regulate vacation rentals, which to some seemed like a good idea, but ultimately we think the governor decided he didn't like it particularly, so the whole idea sort of lost steam. But what happened was important to us is that they revised the way you could read the preemption clause to almost interpret that as affecting our documents. So we found a senator who proposed an amendment on the Senate floor after the Senate version had gotten through all the committees that we thought more clearly protected us, because we said the application of the act may not supersede any current or future declaration of condominium, etc. So that was very proactive on our part. And although it wasn't our bill, we were sort of playing defense against something that could have been very negative for our association. Had we not had our lobbyists there and FLA to come up with those kinds of provisions, we don't know what would have happened. But we made it clear that we weren't going to support anything that they were doing unless we had that protection. And I think that's a good example of how we are very much involved in the process from before the session starts until literally the day the session ends. And as the chair for 2 years, I can tell you on both years of the session end, I got calls from Travis within 30 minutes of the session ending. You know, I was on speed dial. So it's a very active time of the year, and everybody who participates in FLA is very attuned to that whole process. So as I said, neither of those bills passed this year. If you go back and look at the legislative history, you'll see that that they were quite active. One of them died on the calendar. The House bill made it out of all of its committees and didn't make it to a floor vote. The Senate version died in the Rules Committee. So that was one of the examples of it not making through the committee process that Travis mentioned earlier. So with that, I'm going to turn it over to Lisa to talk about emotional support animals.
Thank you, Curtis. You talked about preemption, and that's a very important concept that I also want to address with respect to this law. But as a preliminary matter, hopefully all of you are aware that the federal and Florida state law prohibit community associations from discriminating on the basis of many things, including disability. And disability discrimination includes the failure to make reasonable accommodations in the rules, practices, or procedures if those accommodations may be necessary for a disabled person to equally use and enjoy the benefits of the home or the residence. Well, I've never heard a complaint when it comes to this kind of accommodation when you're talking about a physical disability. I've never heard anyone complain when you can see a disability and you can see the work that an animal performs, regardless of whatever pet policies the association has in place or rental deposits or other types of requirements. Where we see a lot of trepidation is when it comes to these emotional support animals, and people are very skeptical about the veracity of many of the people who are applying for permission to keep an emotional support animal on the property. So let's get back to that preemption issue. Preemption is basically like a jockeying for position. And if something is preempted by the federal government, it can't be regulated like by the state. Just like Curtis was talking about with regard to short-term rentals, if it's preempted by the state, it can't be regulated by the municipalities or the counties. So there is a question as to whether any of the changes made to the Florida statutes regarding emotional support animals will be preempted. Will they actually control if challenged? But I think some of the changes that were made this year are particularly helpful to community associations because it does provide a little bit more guidance for the person requesting the accommodation, for the housing provider that is reviewing the materials that are submitted, and also it includes some penalties, which hopefully will be used sparingly, but of course can create a deterrent to fraudulent or not verifiable claims of disability. So what do they do? Well, the disability is not readily apparent. It allows you to ask for medical documentation, and that's basically what it allows you to ask for documentation substantiating that the person is disabled and that the accommodation is necessary for them to utilize and enjoy the dwelling the same way. It's not medical documentation. I'll get into that for a second. What this did was it addressed the issue of out-of-state providers, and it said you can have your substantiating documentation from a medical provider, obviously within the state, and obviously a treating provider. Let's say if you live in New York half the year, Florida half the year, your treating provider from New York would not be questioned. But what we see quite often are providers that are from states that have absolutely no connection with the person claiming to be disabled. So this law, which is intended to take effect on July 1, would scrutinize those out-of-state providers a little bit more. It would say that they're verifiable or they're reliable if the out-of-state provider have provided in-person or actual treatment or care to the disabled person. So not just filling out a questionnaire on a website or having a 20-minute conversation on the phone, although telehealth providers are permitted in Florida and across many states, there has to be personal knowledge that there is an actual disability and that the accommodation is really necessary for the disability. Let's take that a step farther. That's where we don't see that the disability is apparent. What about if the disability is not apparent and we also have no understanding of how the animal is going to alleviate any of the symptoms associated with the disability? This law does allow you to ask some additional questions, including why the particular animal sought would provide, if not any work or assigned tasks, how would that animal provide therapeutic emotional support to assist the disabled person alleviate one or more of those conditions. It also provides some more direction when it comes to additional animals. If the person requesting a disability accommodation wants to have more than one animal for emotional support, the provider would have to explain why each animal is necessary, what role each animal plays in alleviating one of those conditions. And the crux of the issue is that this statute, once it becomes law, contains a penalty for the actual providers if they provide documentation supporting the need for the emotional support animal without personal knowledge of the disability or the disability related need for the animal requested. Same is true, likewise, conversely, on the requester side. If a person submits false information or information that they know is knowingly and willfully wrong to the association in order to substantiate their request for an emotional support animal, then that they could be found guilty of a misdemeanor, and that carries some significant penalties. So I do want to, again, reiterate that once these laws go into effect, it's hard to know how they will be interpreted by the actual investigators and what will happen in the face of a challenge. But I certainly feel that our community association clients and friends will revel in the need for this additional clarity because the issue is just so wide open. That being said, we're going to turn over to Barry Scarr to talk about the Florida Insurance Guarantee Association changes.
Well, thank you, Lisa, and welcome everybody to our first Legislative Alliance webinar. We're very happy to be able to do this. So FIGA, the Florida Insurance Guarantee Association, it was created in 1970 as a safety net for policyholders or insureds in the event of a carrier or company insolvency. Believe it or not, since 1970, the FIGA has paid out over $25 billion towards insolvencies in all types of insurance except workers' comp. That's not part of this deal, but all types of, property and casualty, life, annuities, etc. And part of that deal when they created FIGA was that they were going to provide a guarantee to condominium associations in the cumulative amount of $100,000 per unit per building. So if you had a 10-unit building, you had $1 million safety net guarantee in the event that your particular carrier at that time of a loss, like a cat loss or a hurricane event, was unable to meet their financial obligation to the association. The problem, of course, being that that's kind of an old number, not really relevant anymore. We've been working for the last couple of years, and Travis has been very helpful and our attorneys and everybody to try to get someone to listen to us. That's not enough money, 100,000 per unit. Obviously, units are worth 5 or 6 or 10 times that now in the replacement values. So we were finally able to get all the parties involved in this to come together, and we got that approved in both chambers, the House and the Senate, to move to 200,000, cumulative amount of 200,000. So that 10-unit building would be now, you'd have the $2 million safety net. Our objective is to get this to 250 or 300,000, and we'll continue to be doing that to try to achieve that. But we think it's a great achievement to provide financial stability to our condominiums in their insurance with their insurance program. And it's again, we've been doing this for 3 or 4 years and finally came through. I wanted to give special thanks to several people that helped make this happen. Senator Jennifer Webb in Pinellas County really helped spearhead this for us, and Tim Meenan, who's a counselor for FIGA, really helped us find a way to do this that would not create a tax event for the state. And we used existing citizens insurance assessment points that they were not using to shift it over to FIGA, and everybody agreed that it made sense. Also wanted to thank Bill Bilowski and the Alliance of Bayway Communities, and also in Pinellas, who really helped get a ground-swelling group together to get board members and managers to get to our legislators and support this bill. Thank you.
Barry. I'm going to step in now, and I'm going to talk about 2 bills actually that did go through the House and Senate and have been signed by the governor. So as Lisa mentioned and Barry just mentioned, and Curtis will be back to talk about a third, there are 3 bills that are waiting to go to the governor for his consideration, and we anticipate he'll sign them. But until they are signed, they're not officially law. The next 2 I'm going to discuss, though, have both been signed by the governor and have taken effect immediately. The first one has to do with law enforcement vehicles. Senate Bill 476 What happened here was there was a police officer in Clearwater who brought her police vehicle home, parked it on the driveway, and the association there said that that was a violation of their covenants and started fining her. This information got up to Tallahassee, and it was, in my 10, 15 years of experience in Tallahassee, and Travis, you could probably confirm this, it's about the fastest I've seen a bill go through the House and Senate, get to the governor's desk and be signed. So it's taken effect immediately, and it is basically, it refuses to, an association cannot refuse to allow a law enforcement officer from bringing home their law enforcement vehicle and parking it in the community. The bill, the law, which is only a single page, so it's easy to quick reading, does define what a law enforcement vehicle is. So it does limit it. It's not going to, it doesn't extend to any vehicle that is outside of what the law enforcement vehicle is defined as, and that's in section 943.10 of the Florida statutes. So it has to be a vehicle of a person who's vested with the authority to bear arms and make arrests, and whose primary responsibility is the prevention and detection of crime or the enforcement of different laws, penal, criminal, traffic laws. So it's very specific, but police officers are permitted to park their their law enforcement vehicles in communities, and any covenant or restriction that that someone might think that's in violation of will no longer be enforceable. So that's number one. That is effective immediately, has already taken effect. It's in play now. And then the second one, also a one single pager, is a fireworks bill, Senate Bill 140. It's a very narrow application. Basically, what the bill is, it's passed, it's in the law now, and there are 3 designated holidays, which is New Year's Eve, New Year's Day, and 4th of July, that fireworks can be set off. I will say the bill, like as I mentioned, has a very narrow application. And what essentially it says is that if a homeowner association, if the community in a homeowner association wants to prevent, or I should say if a board of directors wants to prevent these designating of fireworks on those 3 particular holidays, it's going to be required to be a covenant. Go through the amendment process in your declaration. It is not going to be acceptable just as a board-made rule. Okay, the law is very specific to homeowner associations. It does not have application in the condominium or cooperative setting at this time. So we'll have to see if that bill gets further expanded or clarified in upcoming sessions. But also be aware that while the bill is specific in its application, it does not preclude also if you have municipalities who have certain regulations in place, those also still need to be followed, regardless of the day, those 3 holidays. So those 2, the law enforcement vehicle and fireworks, they are current law, and they are in place. And so that's what I want to share with you. And I'm going to throw it back to you, Curtis, to talk about the last bill.
Curtis, you're on mute. There
The
you go.
last bill I want to talk about is a good example of how things will change during a legislative session, and specifically how ideas that FLA has can influence other legislation as it moves through the process. And this comes back to a meeting, our face-to-face meeting that Michael talked about in 2019, where one of our members, I believe from Orlando, said he was getting wind that there were people going around looking at association documents, and if they found provisions that could be deemed to be discriminatory under applicable state and federal Supreme Court cases with respect primarily to prohibitions of housing being provided based on race, color, national origin, religion, gender, or physical disability, that people were bringing nuisance claims with HUD. And somehow they were using the documents that are recorded. They would do a scan. If they found these, they would file that. And even though the associations had no intention of trying to enforce these discriminatory provisions. So we put language in our bill that would have effectively modified all 3 of our our operative chapters to preclude that. The Florida Land Title Association, the Florida Bar, heard about our idea, and they thought it would be better to deal with it in a different context, which was in the Marketable Record Title Act, which is Chapter 712, which deals with all title transactions, because the way they viewed it, these things could crop up in any sort of recorded title document, and they should be deemed void from the time they're recorded. So we had our bill, which had the provisions in it. We had the Bar and the Land Title Association's provisions dealing with that in two bills. And then what happened, though, was that Senator Roussan from St. Petersburg had filed a bill, which was Senate Bill 374, and his bill only modified Chapter 760, which is the Florida Civil Rights Act, and it's a chapter entitled Discrimination and Treatment of Persons, Minority Representation. His bill made a variety of changes in that chapter. It didn't mention MARTA, and it didn't mention discriminatory provisions at all. So his bill was moving through his committees. There was a companion bill in the House. We had our two bills in the House and Senate, and then we had two bills that had the MARTA language in it. So they had a total of 6 bills that were moving through the process. Senator Roussan's had a better chance of getting, well, it did get through all his committees and got through all the House committees too, without objection. So here it is sitting on the floor of the Senate, and our bill and the MARTA bill were getting bogged down in committees. So through a variety of magic, I call it, or how the sausage gets made, which I learned a lot about during my 2 years in the chair, they took language out of the MARTA bill that dealt with discriminatory provisions, had it amended into Senator Roussan's bill on the floor on March 6th. And so basically, his bill was the vehicle that Travis mentioned earlier for getting this to occur. And so I won't read the whole thing, but it talks about a discriminatory restriction being void from declared null and void from its outset. And how this is important to associations is that there's another provision that says if any parcel owner or unit owner sees a discriminatory provision in their declaration, they can go to the board of directors, and that board, without a member vote, can file an amendment to take that language out of the document. And this is, even though it's been declared null and void, it's an affirmative act on behalf of the association to say, we don't stand for discrimination in our community, and we're going to amend this out. And so that's really going to be helpful. I mean, we don't see a lot, fortunately, in our documents, but if anyone does have an older set of documents where some language might be in there, you go to your board, tell them about it. They will know about this, and the community association's lawyer will know about it, and you file an amendment, and you get out from under the threat of a bogus HUD claim being filed against you. So that's a perfect example of how FLA perceives an issue that affects associations. We get with other stakeholders, such as the Bar and the Land Title Association, to come up with language. And frankly, I think the language that the Bar and the FLA and the LTA came up with was very good. And but it got bogged down. So here was a vehicle over in the Senate that Travis and others found a way to get this language that's very helpful to us onto it, and it's passed. And as Michael said, it's one of the bills that has passed, and it's now will be sent to the governor, and we certainly will encourage him to pass the bill or sign it. And you may get a request for responses to urge the governor to take action on some of these bills. And if you do get one of those action reports or action requests, please take advantage of it. And Dawn, I think, may speak to some of that a little before we close out. But that's a good example of how FLA worked with other people to be sure something got accomplished that was very beneficial.
Excellent. Thank you guys so much. We really appreciate it. We're going to go to the question and answer portion of the session right now. So if you are participating in the session, you'd like to ask the panel a question about something that's happened in the 2020 legislative session or something they've talked about today, go to your control panel. There's a question tab, post a question in there, and we'll try to get through as many questions as we can to get these questions answered for you. So here's a question. And this is regarding, Elizabeth Turner, I'm not sure that I understand your question. And by the way, other panelists, if you are not speaking right now, if you could mute your microphone because I can hear a little feedback. Okay, let's see. So yes, Elizabeth Turner, please pose your question again. Okay, this is regarding the sorry. All right, I'm gonna go to a different question. So this is for you, Lisa Miguel, so you can unmute yourself and get ready for this question. Does the legislation that passed also ask for alternative treatments?
Absolutely not. No, actually, it makes it very clear that you are not permitted to ask for medical records or about the course of treatment of the person seeking the disability status. So you're not entitled to see their records. It's none of your business as to what the diagnosis is. Really, what's important to the community association is there a disability status? What are the impairments caused by that disability? Meaning, what substantial life activities are impaired as a result of the disability, and how the animal is going to help that person overcome some of the limitations from the disability. So I neglected to mention it before, but it's very, very important that any of the documentation that you receive in connection with one of these types of requests remain confidential. You have to have a way in your association's records to keep that segregated so that it's not subject to inspection and just not readily available to anyone else in your office. And again, you are not the medical provider or giving a medical diagnosis. Really, your role is to evaluate whether the person seeking the accommodation complies with the requirements of the law, and if so, then you are obligated to offer the accommodation, unless it, of course, poses a fundamental change to your operations or it is overly burdensome, overly costly. But again, no, you cannot request medical documentation.
Okay, excellent. And stay on because this one is for you as well. So is the Florida bill that passed consistent with the HUD rules that were updated, the guidance that was released in January?
I'm glad that you brought that up. Actually, I'm participating in a webinar being hosted by CAI tomorrow to talk about the guidelines that were issued in January of this year. There were many items in dispute over the years since the HUD issued its 2013 animal assistance guidelines. And there were, of course, the issue with the websites, and the medical letters became somewhat controversial. So the result of the guidelines was really spurred by some of these disputes, and the Florida legislation is primarily consistent with or substantially consistent with the federal guidelines. The federal guidelines, of course, do not provide any penalties for the medical provider or for the person seeking the accommodation. So our law does go farther in that it allows or provides for a penalty in the case of a fraudulent request.
Excellent, thank you. Travis, did you have
something? If I can just add something real quick.
So yes, Michael, then Travis.
Just real quick on that. What we actually, the HUD guidelines came out the very end of January, and we had been working very hard. There was a bill already there that FLA had been working very actively with, which actually did, in our opinion, go a lot further in trying to cure some of the fraudulent activity And unfortunately, when HUD regulations came out, we did have to modify and remove certain pieces of the proposed legislation, which we were confident would run afoul of federal legislation, which is the preemption issue. So we'll see how, if we can continue to coax HUD to help us curtail more of this fraudulent activity. Travis?
Travis?
Yeah, and I was going to speak just also, Michael, just to that point that two things. First of all, this is a great example of how national and our Florida operation worked very well together. Right in the middle of session, as we were proceeding with the language in this bill, Dawn from DC said, "Hey, giving you the heads up, there's going to be HUD guidelines directly on this point coming." And so I went to the sponsors, to committee staff, to the coalition we were working with the Florida Apartment Association and others in the housing sector, and said, let's kind of put a pause because something's coming. And true to form, as our information is usually very accurate, it came out on January 29th. We then were able to work with committee staff in Tallahassee to make sure that it goes to the preemption issue that Lisa spoke to. Florida law can only go so far on these fair housing requirements and housing issues where the federal government and federal law really have a higher dictate. And so we were able to go just as far as we could. And we were okay. They were okay with the penalties and us adding those penalties. So we worked very closely. So I think we're going to be okay. The other thing I would quickly mention is the legislators working on this as sponsors, and also the legislators that were helping propel this forward, were very concerned primarily in the housing sector. They weren't dealing with restaurants or airplanes or the other places where emotional support animals might be an issue. But in the housing sector, they're very concerned about these online certificates. And they felt like these were like diploma mills where you could just go online, having never, there was no relationship with a provider, just print off a certificate, and then your housing provider was limited. They had to say, okay, and allow whatever. And so they wanted to provide as much ability as they could to verify that information was correct. So that's where you've got to be able to have a relationship with that provider as having been seen at least once, and those kinds of things.
Thank you. Okay, Lisa, I have a couple more questions for you. If the association has a rule regarding the size of a pet, so they don't allow large breed dogs, does that rule then apply to the emotional support animal?
Remember, the main part of the crux of the law is that the association or housing provider has to provide an accommodation in its rules, policies, and procedures. So that means any of your rules are not going to apply, because if the animal qualifies as an emotional support animal, it's not a pet. It's not a pet at all. So there's no pet deposit, there's no pet registration fee, there's no limitations on where the person can walk or dispose of, obviously they have to dispose of the pet's waste in an appropriate manner, but not required to utilize service entrances or go through the garage. Again, this is an important concept. So I would encourage those who are asking questions about the emotional support animals really to tune in tomorrow or some of the other programs, because we do delve into a lot more detail with respect to these issues. And everyone I know has questions when it comes to their obligations for disability accommodations.
Excellent. Thank you. So there is a question here regarding one more question about the emotional support animals, and then I'm going to move on. So what if the emotional support animal becomes a nuisance? There's incessant barking or there's aggression. How can the association handle that?
Well, the accommodation needs to be reasonable. It's called a reasonable accommodation in the policies and procedures. If you have an aggressive animal or an animal that attacks someone, that's simply just not reasonable. And it's not reasonable to expose your other residents to potential harm caused by the animal. So if the owner or handler of the animal can't keep it in control, then the association is well within its right to pursue removing that animal from the property if the owner or the animal handler does not engage in other mitigating efforts to control the conduct of the animal. So in certain cases, I've recommended that the animal wear a muzzle, and that has been perfectly acceptable. But if the handler is not in a position to have that control, then it's no longer a reasonable accommodation, and that's something the association is not required to permit.
Excellent, thank you. Curtis, I'm going to go to you with the law enforcement vehicles. When it comes to the law enforcement new law in effect, do you abide by the documents first or go to the new law?
Well, the law would take precedence over the declaration. That's the point of the whole point of the statute. And in fact, it amends each of the operative statutes to make that clear. And Michael, you may have the statute there in front of you if you want to read one of those provisions. It's pretty explicit.
I mean, whether it's for 718 condo, 719 co-op, or 720 HOA, an association may not prohibit a law enforcement officer as defined in section 943.10 subsection 1, who is a unit owner or parcel owner, or who is a tenant, guest, or invitee of that owner, from parking his or her assigned law enforcement vehicle in an area where the unit owner or the tenant, guest, or invitee of the unit owner otherwise has a right to park. It's pretty straightforward.
Okay, so Curtis, here's another one for you. If the association allows emergency vehicles to be parked in the driveway, but the owner insists on parking on the street, does the association need to allow that or just allow it in the driveway?
Well, if they allow street parking, I think they're not allowed to violate the other parking restrictions, but you can't keep them out of the community, which was what was happening, was that they viewed them as effectively commercial vehicles or something of that nature and tried to get them out. But it doesn't mean that you can just park your squad car in the middle of the street and make everybody else go around you. That was the whole point, was to deal with people bringing home law enforcement vehicles that had city of Bradenton, where I live, or city of St. Petersburg all over them, and that's okay. That's what law enforcement vehicles are about. But somebody up in Pinellas County got upset about it, and it really upset a local legislator who got one of our members on a message during church, and he said, "You fix it." And so they fixed it.
If I may, Curtis, and have Curtis start is exactly the point, though. If the statute says if they have the right to park. So if this community allows parking on the street, then the vehicle, like any other vehicle, could park on the street. But if the community says you park your car in your home, in your driveway, or in your garage, then they are not. That doesn't mean they can park their car on the street because it's a law enforcement vehicle. That's
right.
my
Yes, just because all else being equal, if that vehicle just happens to have a law enforcement siren on it, does not give it the right to be parking everywhere else that it can't be. But if it's parked where another car could be parked, but just because it had was a law enforcement vehicle, it was deemed a work vehicle and then not allowed. That's what this was getting to. So, and it's not just emergency vehicles, fire, EMT, others, those are not allowed to be that.
Yeah, this doesn't cover those vehicles. Right. It's very specific to law enforcement. It has to be someone who has the ability who has the arresting authority, and they are enforcing the penal code. It's not EMT, it's not firefighters, it's law enforcement.
Right, and it's not even a forensic truck. And it's got to be an SUV or a single, a private sedan. One thing that I would mention is when we got approached on this by the legislators that were going to be filing it, they were going to be doing it as work vehicle. And so that was one of those instances where we're a resource, and they come to us when it's dealing with associations, and we said, no, work vehicle, that's way too broad. We can deal with plumbing trucks or whatever. to get to this problem, let's get to the problem specifically, and we were able to stitch that together.
All right, one more on the law enforcement vehicle for you, Curtis. So if the individual if the individual is not an owner, but they're living in the house, they're either a significant other or they are a tenant, are they allowed to park their law enforcement vehicle, or is it just for owners?
It's broader. It's anyone who has a right to occupy the unit, and if they're the spouse of the owner or someone who's otherwise a tenant, they're authorized to be there, and they can have a vehicle in the community. They can bring their law enforcement vehicle and park that in the parking. Otherwise, as we pointed out, otherwise in conformity with the parking requirements.
Excellent. Okay, this one is for probably Michael Bender or Travis. HB 623, Senate Bill 175, changing the rules applying to websites to associations with 125 units to 25 units. Did that bill pass?
No, and it's actually 150 units is what it is currently, and it's only in a condominium. It doesn't apply. So it's 150 units in a condominium, and it has not changed. It remains the law.
Okay, excellent.
Okay.
I'm sorry, I'm looking through the questions. So here's a question about emotional support animals. Lisa, so this one's for you. What happens, well, let's see. Regarding these support animals, what if residents have severe allergies to the animal hair? How do you accommodate those residents?
That's for her seminar tomorrow.
What is the reasonable accommodation for that?
Actually, we weren't even planning to talk about that, but that's called competing disabilities. And I'll tell you that the threshold is pretty high for the association to be able to deny one accommodation as a result of granting another accommodation. The only really case I know about this is from Ohio State University, the Ohio State University, where a resident had, well, a person who's in a sorority requested an accommodation to be able to maintain her dog in the sorority house because of some kind of disability status. I don't even remember what it was. But there was another resident already living in the house that claimed that she had severe allergies, and those allergies were exacerbated by the presence of the animal. And I'll tell you, the court really put her through the ringer. They really made her go through a whole lot of detail for her to be able to prove that it was the presence of the animal that exacerbated her Crohn's disease and her allergies, or that it was other conditions that did so. Plus, there were no other mitigating actions that were taken in connection in the sorority house itself. So they didn't limit what washing machines the two girls could use. They didn't limit what rooms the animal could be in. They didn't have any other types of ways to prevent the woman with the disabilities from being exposed to the dander. So please be somewhat hesitant. You do have to consider every single person that has a disability claim, and if there must be ways for you to be able to accommodate all of those claims, or at least give it the yeoman's effort to try to accommodate all those claims before you deny someone outright.
Dawn, it really is a good advice to tell people who are listening. If you have situations like that, especially in emotional support animals, reach out to your legal counsel. It is important that you get guidance so you don't run afoul of these laws unintentionally and then cost yourselves a lot of time and resources in fighting them.
Because we know that
I mean, I hate to spend a lot of time on this topic, but here's another point that what happened in that particular case was the fact that the woman that had Crohn's disease, the allergies and Crohn's disease, she had already been on record with the university of having a disability, having Crohn's disease, having these allergies. So she had already requested accommodations when it came to her test taking or certain other issues that she wanted to be alleviated from. And that the court weighed that very, very heavily. This was not a girl who said, oh, I'm allergic, get rid of your dog after the fact. This was somebody who had a known condition. And even with that known condition, the court ruled against the school, the housing provider or sorority controller or what have you, and said, no, you could not deny the second woman's request for an accommodation simply because this first woman has an accommodation. You have to find a way to be able to accommodate both.
All right, excellent. Curtis, I'm going to go to you. I have two questions for you. With regards to the discriminatory language in the covenants, can the board change the wording without the 2/3 of a vote?
Well, they can remove it. They ought not make any attempt to clean it up. It's either it's discriminatory or it's not, and it's pretty clear when you see that language that you need to take it all out. No, it doesn't give them a right to rewrite it. All they can do is remove that clause in its entirety, and that would certainly be my suggestion if you find language like that in your declaration.
Excellent. And I'm going to go to the law enforcement vehicle bill. Does that also apply to unmarked vehicles?
Well,
Good one.
yeah. If it's unmarked, who's going to know? Except
Well, that's a good
you
point.
might see a county or city tag on it. Would be about the only way.
Yeah.
But if it's unmarked, it's going to be pretty innocuous.
Okay.
And I just want to remind everyone, Dawn, also the discriminatory language bill, the support animal bill, they have not yet gone to the governor. They are not yet law. So while we anticipate they will be law, they are not. The law enforcement vehicle and the fireworks are laws. The others are still just proposed legislation right now.
And I'll just mention real quick regarding that timing, you know, the governor's office had asked the legislature to not be sending stuff during the COVID crisis while they were dealing with that and unemployment claims and other things. They now have said, okay, you can start sending those bills like the FIGA bill that Barry discussed that would go into effect in July, emotional support animals, these that we've discussed today. So by the end of May, they said by the end of May, you can start sending those over, and then the governor will have 15 days, a little more than 2 weeks to act on them. So within, now that we're a little more than halfway through the month, we'll be seeing those in the next week or so.
Travis, I have two questions for you. The second one, so you can prepare. I'm going to go through these bills very quickly. I want you to tell me, just to reaffirm with everyone, which ones passed and which ones failed. I'm going to do that next. But before that, do you expect the legislature to reconvene to discuss any issues specifically related to COVID-19?
Yes.
And do you expect that there will be community association specific issues that may be that may come up?
The only one that would is the codification, would be the codification of the emergency rule that was issued by DBPR Secretary Beshears that clarified that associations can take these emergency powers measures such as meeting online and other things. Current law says that they're only to be applied during a natural disaster, hurricane, and then the new recommendation order by DBPR was that also would apply to a public health crisis. So the only thing that I would see when the legislature would reconvene in a special session to deal with some budget issues would be that.
Excellent. And by the way, the CAI National is looking at that language and using that model language in other states to be very useful for in times of a pandemic, which I didn't think any of us thought we would be in this position today. Okay, let's go through these bills really quickly. Vacation rentals, did it pass or not?
No.
Emotional support animals, did it pass or not?
Yes.
Not yet law though. It's not yet gone to the governor.
All right, we got that. The insurance, did it pass or not?
Yes.
Law enforcement.
Yes, and is the law.
Fireworks.
Yes, and is the law.
Discriminatory association language, covenant language.
Yes.
Okay, so really the only thing that didn't pass of the bills that we talked about today are the rental bills.
Correct.
They'll be back.
All right. Okay, now I am going to turn my camera off. I'm going to turn on Pilar's camera. Oops, that's not my camera. Sorry about that. I'm going to turn on Pilar's camera so she can talk a little bit about the chapters and connecting with chapters.
Thank you,
Hi,
Dawn.
Pilar. Thanks for joining us.
Yes, thank you. So I'm going to talk to you today about your involvement in your local chapter and many things that are available to you. Starting with, pardon me? Starting with, if you aren't currently a member, we would ask you to seek out membership in one of the local chapters in your area. If you are a member, we would ask you to please engage with your chapter. Our membership categories include community association managers, our CAMs, management companies, business partners, and homeowner leaders. Membership is incredibly affordable, and for an example, we can have up to 15 homeowner leaders join the community association for just $250. Our business partners, there are many opportunities for professional development, including an educated business partner, the RS designation for reserve specialist, certified insurance and risk management specialist for insurance agents, as well as the CCAL for our association attorneys, and there is a professional services directory. Our property managers have many education opportunities through CAI professional development program, including earning your LMS, your AMS, and your PCAM designations. Our CAI local chapters offer many opportunities for networking and education and providing resources for you, for your local community. And now in our COVID environment, chapters have adapted to virtual options, which is fantastic because that means we could actually be involved and share these webinars throughout the entire state. Trade shows are a vital piece of our local chapters. Some have been rescheduled to 2021 and others are happening virtually. So I would encourage you to check out your chapter's website for that information. Our websites do help with many resources and they help navigate complex association issues. Just like you've heard on the webinar today, there is a lot going on legislatively that impacts all of our homes, where we live, where we work, where we play. Overall, in our chapters, we have 4,300 members throughout the state of Florida in our 8 chapters. Previously, you also heard there's 9.7 million Floridians that live in 48,000 community associations. That is a lot of us. Growing our membership and our representation for our communities is critically important. As you've heard today during the presentation, our local chapters provide you with an avenue for involvement in all of this legislation that impacts our local communities. Back to you, Dawn.
Excellent, thank you. I'm going to turn it over to Mary. Mary Macfie has something to add. Mary?
Yes, I think with everybody hearing how the new laws are being put into place and they're all dredged out of something affecting someone somewhere, and with all the old laws that are still on the books, obviously, please, nobody knows better than probably your association manager how these laws really affect an association. Put through laws, they're played out for a while, and then maybe sometimes they need to be adjusted. Please reach out to your Florida Legislative Alliance delegates through your chapters or going through that CAIonline.org site. Reach out to us. Let us know how it's really working.
Excellent, thank you. Team, Michael, Lisa, Curtis, Barry, Pilar, Mary, Travis, you guys have been fantastic. We are out of time. We don't have time to address any more questions or from the audience. Michael, as chair, I'm going to let you have a few closing remarks and then we will close out the webinar. But thanks everyone for being here. Thanks for all the participants and for the panelists.
Great, thank you, Dawn. Thank you, Dawn. Thank you, Travis. Thank you, Emily. Thank you, Lily, who helped us all put this together up at National. And a thank you to the panelists. Thank you all for attending. obviously there's a lot of angst and unknowns going on in the world today, and we just ask that everybody continue to be supportive of each other and work together. Hopefully you got some good information today. What we're trying to say here is that the world is going on. We have sessions going to be coming up. We're going to be working on things in that regard. In the meantime, do pay attention. There's a lot of information being shared regarding the COVID pandemic. CAI, all of the chapters have websites. I know that we have on our site, we have websites, COVID announcements. And also, I will tell you with regard to Florida, as of yesterday, I have the pleasure of being appointed on behalf of our Florida Legislative Alliance to the governor's task force called Reset, which is business leaders working together to reopen Florida. And we'll be bringing our CAI our voice to that group as we get together. And so that's an honor that I'm honored to be asked to do that as well. So with that, I want to again thank everybody. Stay safe and be good to each other. Goodbye.
Bye. Thanks, everybody. I'll be ending the seminar now. Thank you.